Texas passed a law that bans abortions after a heartbeat can be detected, usually around 6 weeks of pregnancy.
This law is different. For the most part, it tries to adopt a relatively strict or restrictive approach to abortion policy.
The law also allows any person to sue anyone who helps a woman get an abortion after that time, from the provider to the driver who brought her there.
The key difference here among the Texas bill as opposed to other laws is that instead of the enforcement mechanism being the state, now you allow the citizens to actually sue in civil court to prevent that abortion.
Political science professor Robert Preuss says when states have pushed further restrictions on abortion in the past, the biggest blockage has been the Supreme Court, because the abortion seeker or provider can sue the state. However, with this law, that's not the case.
This new law from Texas has a unique way of approaching enforcement, and so therefore it's still up in the air exactly how far the Supreme Court will let this stand. So far it has.
We've seen other abortion statutes that authorize private individuals to sue, but we've never seen anything that allows quite literally anyone to sue.
Mary Ziegler is the author of multiple books on abortion.
It does seem that the federal government has limited options to change what's going on in the ground in Texas.
She says the Texas law is more difficult to challenge.
There's no state actor you can sue. And to bring a constitutional challenge, you can't sue a private citizen because the Constitution only gives you rights against the government. So then it creates a catch-22.
Constitution law expert Ernest Young says those fighting the Texas law will have to find a different way. The Department of Justice's lawsuit is one possibility.
Once the law is actually challenged in a posture where a court can rule on the merits, that would raise as one of the issues whether the court is going to continue to follow Roe versus Wade.
Roe versus Wade currently gives pregnant women the choice to have an abortion without excessive government restriction.
The most interesting things are likely to happen in those state court lawsuits as they progress.
Robert says what happens in Texas will be a big indicator of what we could see elsewhere.
If this law does stand a constitutional test, then you will see Republican-held governments, state governments adopting further restrictions and probably modeling those restrictions on something very similar to Texas.
The Supreme Court hasn't allowed a law like this since the ruling on Roe versus Wade, but later this year, the High Court is also expected to hear a case from Mississippi on a law that would ban abortion at 15 weeks. That decision could also affect abortion laws across the country.
If the Supreme Court wanted to hear this case, that would require the court to either say Roe v. Wade is gone or part of Roe v. Wade is gone, which is to say you can ban at least some abortions before viability. And that's why it's such a major event, because there's no way for the court to uphold this law without either undoing or rewriting what it means to have a right to choose abortion.
We don't really know how this is going to play out.
I'm Chloe Nordquist reporting.